Thank you, everybody, for joining us. My name is Abigail, and would like to welcome you to our webinar, What to Do About Bad Actors Causing Trouble on the Water. Jim Lang will be our presenter, and we wanted to go over just a few housekeeping items before we get started. We just ask that all cameras remain on mute during the course of our webinar. If during the webinar, if you have any questions, feel free to drop those in the chat function, and we've saved time at the end of our webinar to get to those. And lastly, we'll be recording today's webinar. So if you miss anything or you want to go back and hear it again, you'll be able to visit our website and view that at a later time. Now I'd like to introduce you to our host, Jim Lang. Jim focuses his practice on protecting Virginians who live, work, and play on the water. He established the Waterfront Property Law Practice Group at Pender and Coward. He and the 3 other attorneys in this group routinely handle all aspects of riparian property rights law, maritime and admiralty law, and environmental law. Clients consistently turn to the Waterfront Law Team when they need help in court at the local wetlands boards and with the VMRC. And with that, I'd like to turn it over to Jim.
All right, well, good. It's now good afternoon, everybody. I'm really glad to have you join us. We've got a great collection of just friends on this meeting today. And we figure with Memorial Day coming up, what a time for somebody to be enjoying the outdoors, next to their beautiful waterfront home. And yet some of the people out on the water might be a little bit more, shall we say, energetic than they might be on other times of the year. So we're going to try and cover those kind of points. And what I've just put up as an outline of the main points that we're going to cover today. Bottomland ownership, you're going to hear a lot about that during this session. And it's also important that you keep in mind the difference between lakes and ponds on the one hand, and then bays, rivers, creeks, and the shore of the sea on the other hand, because different legal regimes for those 2 broad categories of water bodies. We'll touch on admiralty and maritime law a little bit during this session, and we'll also talk about how law enforcement can come and help you. Just imagine it's that time of year, your son or daughter or grandchild has graduated from college, and you're having a beautiful party for him or her in the backyard of your beautiful waterfront home, and up come these guys on their jet skis roaring by, making all kinds of noise, and not creating the kind of atmosphere maybe you were looking for your party. And if it's not those guys, maybe it's these folks on spring break who are full of exuberance and joy and wanting to express it, and it's drifting across the water. In fact, maybe they're right next to your shoreline, maybe they're right next to your dock. And what about that? Is that okay? Or what about you have a private lake, let's say it's Lake Witch Duck in Virginia Beach, and you can't figure out why you're not catching any fish anymore. And what you learn is that this fella who isn't a resident there and doesn't have permission to be on that lake, well, he's the guy in there who's cleaning out all the, I think those are bass, I'm not sure. You can take a look and judge for yourself. So we'll touch on all these during our webinar today, and we'll just jump right in with to prepare to talk to you today. I interviewed police officers from throughout Hampton Roads, 3 different jurisdictions, and I wanted to hear from them what are the kinds of things that make your phone ring at the police department, and how do you handle them? And the complaints they receive fall broadly into the categories that you see here on this slide. And so we're going to touch on each one of those things issue by issue. And you don't need to worry about writing any of this down. We're recording this webinar, and we will put it up on my website probably in about 10 days or so. It'll be accessible to you then, including the PowerPoint slides, and you'll be able to pull it up and get all this information. So let's start with trespassers. I've got 2 slides for you on trespassers. But the key point is who owns the bottomland. If the bottomland is privately owned, then the owner of the bottomland can prohibit outsiders from coming onto the water and fishing, boating, swimming, and the like. Now, if you own the bottomland under the water, it's really no different than the land you own that's not covered up by the water. And so you can think of it this way. Certainly, nobody could come over to your front yard and install a swing set for their kids to play on unless they got your permission. Everybody would agree with that. Well, the same principle applies if the bottomland is privately owned. It's just land covered by water. Nobody gets to come onto that water and enjoy recreational activities or really any other purpose unless they get your permission. So what bottomland is privately owned and what bottomland is not privately owned? Well, that's the next 2 bullets on this slide. If it's a lake or a pond in Virginia, that bottomland is going to be privately owned. And, I'll give you some examples here from the Hampton Roads area, Lake Christopher or Lake James, just up Kempsville Road near the intersection with Indian River Road, or Lake Witch Duck, up north of Virginia Beach Boulevard, Sherwood Lake down in the southern part of the city. All of those have privately owned bottom, and whoever owns that bottomland has the right to control what happens on that lake. Another category of privately owned bottom, there are developments in our area that, big subdivisions that when they were planned out, they were near a river that, let's say the Lynnhaven River, and the developer wanted the water to extend up into the properties that they were going to sell as private residential lots. And so the developer dug canals, and those canals filled up with water that the water now comes right up to those people's homes, and they have a dock and they have a boat. But that land, before it was converted into a canal, was privately owned. And the fact that you dug a canal and allowed the canal to fill up with water doesn't change the private ownership of the canal. So we have canals in our area, some of which are privately owned. And the person who owns the bottom land under that canal has the right to control what happens there. Another example of privately owned bottom would be the stormwater ponds that you see in and around our area, and indeed in and around the state, or these borrow pits that are filled with water. Another example, privately owned bottom. Now, you might be thinking to yourself, okay, that all makes sense, but I've been out to Smith Mountain Lake and I run around that lake all over the place, and nobody is trying to tell me that I'm trespassing. Lake Anna would be another example of a very large lake in our state with privately owned bottom, but it's in a little different category than what I've just described. And let me tell you how that came about. Smith Mountain Lake, for example, was a mountain area, and it didn't become a lake until the power company installed a dam to create the lake. And when they did that, then all those little private properties on that mountain got flooded with water. And before that could happen, the power company had to go through a condemnation proceeding to acquire the property interests in all those private properties all over that mountain before they could flood that mountain or the canyons of that mountain with water by creating their dam. And part of the deal when the power company went through the process of condemnation was that they had to allow people to use the lake. And so if you live on a Smith Mountain Lake or a Lake Anna, that bottom is privately owned. It's privately owned by the power company usually, Sometimes there's a little different arrangement, but the point being, it's the power, that power company is still exercising control over what's going to happen on that lake. Now, you'll also have law enforcement out there because there are statutes, Virginia statutes, about how you operate your motor vessels and your sailboats and the like. So you'll still have law enforcement out there on those big lakes, but the bottom is privately owned. It's just sort of a mixed situation, which is a little different than the stormwater pond in the back of your house where you own the bottom and you can control it flat out and you're on your own. So that's privately owned bottom. The other category is creeks, rivers, bays, shore of the sea. That bottom is usually state owned, almost always is state owned. There are a couple of exceptions that we're not going to go into here. But as state-owned bottom, what you're going to have as a waterfront property owner is a lot less control. The amount of control you're going to get is going to come from your status as a riparian property owner. And you will be, as a riparian property owner, entitled to a riparian area adjacent to your upland property. And within that riparian area, you will have 5 specific rights. For example, you're the only one who gets to build a pier in that riparian area. Nobody else gets to. And you're going to have the right to use the water in certain ways. But you're not going to have the power to keep others out of that water body that has state-owned bottom. And so just a far different level of control. Now, under both the situation for the privately owned bottom and the state-owned bottom, both of those bullets, you'll see a reference to an article on my website. And each of those articles goes into a lot greater detail about the level of control you have, depending on whether your water body is state-owned bottom or privately owned bottom. At the bottom of this slide, I made mention of the question of, well, let's suppose I'm a waterfront property owner and there's a terrible accident in the water right next to my house. Somebody drowns, just for example. Am I liable as the waterfront property owner? You'll see that I've given you a reference to an article on my website that goes into this issue in great detail. But to give you just a broad outline of how it works, it depends on whether that water body is over privately owned bottom or state-owned bottom. If it's a privately owned bottom, then the law that's going to apply will be the premises liability law that applies upland. So, for example, if it's a privately owned bottom and the person who drowned was a trespasser, it's going to be almost impossible for you to have any liability at all. If the person instead was somebody you invited to the property, and they were swimming in your pond, and they drowned, and they sued you, they would be in a different category. They're not a trespasser because you invited them to the property, so they would be a licensee. And the duty you owe to a licensee is to warn them of any hidden, non-obvious hazards. So, so long as you met that duty, you would not have any liability. And then lastly is the business invitees. And that group of people, now that group, that's, for example, if at your private lake or your private pond, you opened it up as a marina or a swimming beach, and you had a place for people to eat, you had entertainment, and you wanted people to come, and you charged money. So you're inviting the general public in. That group at your privately owned, at the water body that has privately owned bottom, you're going to owe a higher duty to if you didn't extend reasonable care to those people, you could be liable for whatever injury that occurred while they were there. Thinking about liability for out on the water, if it's state-owned bottom, which is probably the majority of the time, all you owe that person who had that terrible accident is whatever the duty of reasonable care would be. And chances are you wouldn't have much exposure to liability at all. But that's all broken out in great detail in the article that I've given you. I've got one more slide about trespassers on your water body. You've got two avenues into the legal system if you want to do something about that trespasser. Civil trespass. That would be a lawsuit that you file against the trespasser to make them stop, and if they cause damage, to recover money damages for the harm that occurred. That would be a lawsuit that you would be you would probably want an attorney to help you, and my team knows how to do those kinds of lawsuits, but you'd be looking at legal fees to fund that litigation. And because of the cost involved, I think people are very often thinking about the alternative, which is, wait a minute, I've used my tax dollars to create a police department, so instead of paying Pender and Coward to prosecute a case for me in court, why don't I just call the police? And if you do that, I've given you the code reference for trespass. I've given you the penalty that is theoretically possible. And so the police officer can come out to your property, somebody's trespassing on your privately owned bottom, and they can issue a summons to that person, which makes them come to court and answer to a judge. Or you can alternatively, if the police officer doesn't want to issue a summons, or you and the police officer decide a better strategy would be for you to go to the magistrate and get that going yourself, you can do that as well. Key point, when we're talking about the criminal law, criminal intent is always at issue. They call it mens rea in the criminal law. A person can't be convicted unless they had the requisite intent to commit the crime. And so it's the key here, and it's actually written right into the words of the statute, that violator had to be warned either orally or in writing. So that's the importance of that no trespass sign, having the no trespass sign up there. The other thing about this, another way to have really great evidence about that they were warned, was the person's out on your private lake. You call the police come. Together with the police officer, you tell the person, this is private property, you need to leave. And the police officer witnesses you orally warning the person. And the person leaves, but then they're back next week. Well, when they come back next week, you can either call the police and have them come back and issue a summons, or you can go get a summons from a magistrate, but have that police officer at the hearing to testify that the person was warned, they knew, and they came back. I've got a bullet in here about if it escalates. We had a case in the last year where our client owned property on a canal that was privately owned, and some fishermen in their boat came up the river and then through the canal right next to our guy's property, and they're fishing there. And our client goes out and says to these people, hey, this is private property, please go fish someplace else. And the fishermen did not respond in the way you would have hoped. The situation escalated. Our client went into his house and came back out with a gun, and things got really ugly at that point. You don't want to have that kind of a situation. You don't want to have a confrontation. It's best to get the police involved if you've got a trespassing situation on your water body. They know how to handle these kinds of confrontations. And the only decision really for you is, am I going to call on the 911 number, because I think this is a really big deal, and it's going to escalate, or you call on the non-emergency number, but either way, get the police involved. When that officer shows up, you want to have a plat showing your bottom land ownership, because they have no way of knowing where the property lines are out in the water. And they're going to want that when they show up. They're going to want some proof that you own that bottom land. And so having something from your real estate records demonstrating your ownership would be a key piece of paper to have when that officer shows up. And then I did ask the policeman that I interviewed, okay, so if my client does everything correctly, he has his plat, calls you, you together with my client confront the person who's trespassing, they leave, then they come back. And so then you come back, you issue them a summons, now we're in court. What's really going to happen? I know 12 months and $2,500 is the possible punishment, but really what's going to happen? And what they told me was that so long as the person who's been cited was courteous to the officer, that's always key, and courteous to the landowner, and in court conducts themselves, reasonably and respectfully, and acknowledges the problem and promises never to do again, 75% of the time they're going to let them off with a warning. Occasionally, though, that's sort of the 1 out of 4 case where they don't get off with a warning, they'll enter a deferred finding, which is they find them guilty. But if the individual keeps his nose clean for the next year, then it's expunged from their record. It's called a deferred finding. But if the person that's in front of the court was a bad actor, mouthed off to the officer, disrespectful, and ends up in court, that person is going to end up getting convicted, and they're going to get a fine and maybe some jail time, depending. But that's trespass on a private water body. We opened this up with a picture of some folks on a jet ski and some pictures of folks in a boat. So reckless operation. I've given you 2 code provisions. One is for boats, and the other is for personal watercraft. And we're talking jet skis. And the General Assembly has set up 2 different regimes, depending on whether you're in a boat or a jet ski. For boats, it's a very generic, just like for cars, don't operate in a reckless manner. And if you do operate in a reckless manner, you're facing a potential Class 1 misdemeanor. For jet skis, the General Assembly put a little meat on the bones as to what would be considered reckless. And you can see them there, weaving through vessels, or following another vessel and jumping the wake, or turning sharply to spray an object or person. So you can read that, and you just imagine there's been some experience with jet skis that brought about these very specific kind of prohibitions. So if those kinds of activities are happening out in the water next to your house, it'd be the same as with the trespasser. You're going to want to call the police and get some assistance. I've got 3 slides for you on reckless operations of boats and jet skis. This is where some of the Admiralty and Maritime can also come in. If you end up with that boat or the jet ski causing damage, they wrecked your dock, they hit your boat, they ran over a person and hurt them. If you're going to come to an attorney and you're going to ask for help bringing an action in court to get a recovery for that damage, and we are going to use the inland navigational rules that I've shown you here, along with the Virginia Code provisions that I showed you on the last slide. Now, I did include on this slide a reference to the Coast Guard having a responsibility for enforcing and talking about the civil penalty that's available. But I don't think the Coast Guard is going to really be involved with, a jet skier next to your house. I think it's going to be more the local police But nevertheless, you've got all of this, a whole separate legal regime that is available for this situation. And then a few other references out of the Virginia Code. I found particularly interesting the 50-foot standoff that you see in the first code provision, 29.1-744.3. It's unlawful to operate your motorboat, but note there's a carve out for the jet skis. Jet skis are not subject to this code provision, but unlawful to operate your motorboat at any speed greater than the slowest that you can possibly go while still maintaining steerage, if you're within 50 feet of a structure or a person in the water. So if you're within 50 feet of somebody's dock, you have to be going slow in your motorboat. If you're within 50 feet of a person who's in the water, same story. They really, though, the General Assembly really dialed back the potential punishment on this. Everything we've looked at up till now is a Class 1 misdemeanor, which is the highest level of misdemeanors, potentially carrying a 12-month jail sentence and a $2,500 fine. By the time you get down to a Class 4 misdemeanor, which is the lowest level of misdemeanors, the maximum penalty is $250. You're looking at a traffic ticket kind of stuff here. And then I've given you some code provisions that talk about if you're involved in a collision and your obligation to stop and render assistance. And I found it very interesting to see that if your collision resulted in serious injury or death and you didn't stop and render assistance, you're looking at a felony. But it's a misdemeanor if your collision only caused property damage. But that's reckless operation of boats and jet skis. Let's talk about wake damage, because all that, zipping around on your motorboat or your jet ski is going to throw a big wake, and the big wake is going to cause erosion to the waterfront property owner who just, spent a lot of money installing that beautiful new living shoreline, or is going to cause damage to that pier or other water infrastructure. The operator of that vessel is liable civilly for that damage. And again, to recover for that, you'd be looking at coming to attorneys who have the kind of experience that my group has to file a legal action to get that recovery. And we've handled those kind of cases. Had one where it was a Coast Guard vessel of all things that had was going up the Elizabeth River a little bit faster than it should have been going, and my client was a construction firm and had a barge-mounted crane that with the boom extended and a load on the crane, and when that cutter went by at too high of a speed, it threw a wake that had that barge tossing back and forth, and the load on that crane swinging wildly and causing damage. And we were able to recover for that because of Inland Rule 5, which I gave you a little overview of the Inland Rules a couple of slides ago. Specifically for this case, you use Inland Rule 5, failure to maintain a proper lookout. You can also use the Inland Rule that talks about safe speed. But for wake damage, you're looking at recovering on your own. Although you could call the police because it is a misdemeanor to violate the no wake zone. And then we do get questions from time to time about, I would like to have a no wake zone near my property. And I've given you the code provision for how that works. And then I suppose there could also be the people who like to run around fast on the water on their jet skis, who might like to see a no wake zone being removed, or no wake buoy being removed. Either way, if you want to create a no wake zone or remove a no wake zone, I've given you the code provision for how that works. So that's wake damage. Memorial Day coming up, boating under the influence is always a real concern. I've given you the code provision for that. It's for cars, it's called driving under the influence, or DUI. For boats, it's called boating under the influence, or BUI. But it's the same blood alcohol levels as for a DUI. They're also looking for people who are impaired due to drugs, and it can be illegal drugs or it can be prescription drugs, either way. And one of the police officers I spoke with told me that he said, we now have a DRE. And I said, what's that? And he said, it's a drug recognition expert. It's a person who's skilled in evaluating people who are impaired because of drugs in their system, prescription drugs, illegal drugs, no matter. And told me how they're going to have that DRE person out on the water with them over Memorial Day, which I think is a good thing. Notably, the prohibition about impairment only applies when you are underway. So if your boat is at anchor and you are impaired, it's okay to be impaired while your boat is at anchor. What's not okay is to be impaired while your boat is underway. And again, class 1 misdemeanor is what you're looking at there. The officer from Virginia Beach told me they have about 10 BUI prosecutions a year. I would have thought it was more. Noise. You were trying to have that wonderful celebration in your backyard, and up come in their boat those loud, boisterous young people who are home on spring break. What about the noise they're making? Well, there is a code provision that talks about engine noise, and I've given you that. But I think the more prevalent concern is probably just loud music or other, shouting and such. And that's all going to be regulated by local law. And while in getting ready for this, I talked to representatives from several jurisdictions. I'm just giving you a representative ordinance out of Virginia Beach for how they deal with noise. And you can see they've got different standards depending on time of day. So at night, you've got to be a little quieter than during the day. You can be a little louder. You can see the decibel levels there. The key point, though, is that the decibel level is measured inside your residential dwelling. So let me unpack that. There's two pieces there as to the noise. One, the measurement is taken inside your house. And then the second is, in order to make the measurement, you have to have the right equipment. And the Virginia Beach ordinance tells you what kind of equipment you have to have. The point being, it's probably not something that most of us are going to be able to evaluate in a way that would lead to potential summons being issued to somebody with any equipment that we have lying around the house. But nevertheless, this would be something you could call the police about, and they would respond and they would help you. And I think they probably do have the noise measuring equipment. I would guess that they do, but I didn't specifically ask. Let's talk for a minute about throwing things in the water. There's for the Virginia Code, there's a generic prohibition about discharging any waste into state waters, and it has some pretty harsh penalties. Up till now, we've been talking about a class 1 misdemeanor or a class 4 misdemeanor. You violate this one, and it has bigger teeth than that. But that's about as specific as I can be, because a lot's going to depend on the circumstances, like how much did you discharge? Did you meet your obligation to notify the authorities? How bad was the environmental impact of your discharge? There's a big difference between somebody who discharges poison into the water that causes a fish kill that sends dead fish up on a half-mile of shoreline, as compared to somebody else who threw a couple of beer cans into the water. but you've got that generic prohibition against discharging waste. Now drop down to the bottom of the slide, oil discharges. And this comes up because motorboats use oil, and oil sometimes ends up in the water. So I've given you the code provision that talks about the liabilities to reimburse for the cleanup cost and damages suffered by third parties. You think about a big oil spill, it hits the shoreline, and it can interfere with businesses that, maybe do, nature kind of treks. They're gonna be out of business in that area for a time, or it could be, another type of business, a commercial boat yard, for example, and their ability to operate could be interrupted if they've had a bunch of oil hit their shoreline. And so the discharger is going to be liable for the damages suffered by those third parties in the oil spill situation. And then again, you see again the obligation to notify authorities. You have to self-report these things, and if you don't and you get caught, then you're going to be sanctioned much more heavily than if you did make all the proper reports. And then I've added in the Virginia Beach Ordinance, which is much more generic, but don't go dumping any garbage in the water. And I've given you what the potential sanction is for that. So that's discharging garbage or pollution or oil in the water in a nutshell. And on my website are several articles about discharging oil into the water, oil and hazardous substances, if you want to drill into this a little more. The last item I have for you is you've got this beautiful waterfront property, and you come out in the morning with your morning cup of coffee, and you see this on the shore next to your property. Happens more than you would think. And it's very frustrating when it does happen. One of the police officers I spoke with said that, when these, these recreational vessels, or these smaller, 30, 40-foot vessels, they get to the end of their useful life, it's too expensive to keep it up, then the owner can't sell it, no one will buy it. And the owner's looking at, maybe a couple $1,000s in disposal costs. And so they're looking to avoid that cost. And he said what they do is they scrape off all of the decals on the boat, the registration decals. They get a grinder and they grind off all of the identification numbers. And then they look for a place to just dump it and leave. And this picture that I'm showing you is from Norfolk from a few years ago, sitting on a shoreline. And what are you going to do? Well, I've given you an article on my website that talks about this, but you're not going to really like the answer that you see there, because as the waterfront property owner, it looks like it's going to cost you money one way or the other, and none of this was your fault. And so I put this under the category of when you live on the water, it just costs more than when you don't live on the water. You're gonna spend some money dealing with this. Unless you live in Hampton. I talked to the police officer I spoke with in Hampton, said, nope, we go out and the city will retrieve that vessel and the city will dispose of it. He says, and for that reason, we don't have very many in the waters in the city of Hampton. But I can tell you this vessel was sitting in Norfolk for years before this vessel was on property adjacent to my client's property, and we got it removed, but it was an effort. And it's not like the person who did this can do this without risk of being prosecuted. I mean, you're giving you the ordinance in Virginia Beach. I imagine there's similar ordinances in the other cities around here that prohibit abandoning a vessel on somebody's property. But the trick is to catch the person who did it, and so that's what you've got on abandoned vessels. And with that, we've reached the point where I'd be happy to take your questions, if there are any.
You know, since it's such a small group, we did have a question come in from Peter. Peter, did you want to just go ahead and ask your question directly to Jim? You're on mute, just so you know.
Yeah,
Okay.
I was trying to slew the little cursor over there. Well, I had a couple of questions that came up as we went along, and I sent two of them, but I might even have another. So what, in terms of defining what is water bottom and what is land, does mean low water have, I mean, is that an applicable way to measure where that dividing point is?
That's a great question, Peter. And the answer is that if you are on a tidal water body with state-owned bottom, then the property line is going to separate your upland property from the bottomland owned by the state is the mean low watermark. And I think you'll find that in Virginia Code 28.2-1202. Let me give that to you again, because I know I just rattled it off. Give you a chance to write it down. It's Virginia Code 28.2-1202.
Okay.
The mean low watermark. Now, if you have privately owned bottom, like one of the lakes that we talked about earlier, then you're not worried about mean low water. You're not worried about where's the line between me and the state owned bottom. Instead, your property line is going to be whatever is in your deed and in your neighbor's deeds. And that kind of brings up another point that I would add to our discussion about your ability to control what happens out on the water at your lake or pond. There are two different ways of writing into a deed for a privately owned lake or pond, two different ways of describing the ownership interest. And if your deeds are written in the first version, then you have all the control in the world, even to the point where you could go out to that lake or pond and you could put up a fence to keep others out. I mean, it seems so counterintuitive to me that anybody put a fence in a pond, but you could do that. Just like you can put a fence in your front yard. You probably have to get a building permit from the city, just like a fence for your yard. But other than that, there's no restriction. But if on your lake or pond, your deeds are written in the other version, the second version, you still have the ability to control, but your ability to control gets exercised together with the other people who live on that lake or pond. So a little bit different level of control. But anyways, does that answer your question, Peter, about the mean low watermark?
Well, it does in a way. Obviously, I'm on tidal water and I do have a mean low water line, but then that raises the following question, which has to do with riparian rights. Is it possible that a property can have riparian rights but not own the property, the land that's under between the mean low watermark and the actual property line?
Okay, good question. Raises several points. The first is if your property has a boundary that doesn't get to the mean low watermark, like there's an intervening strip of property that separates your property from the mean low watermark, that means your property is not riparian and you don't have any of the riparian property rights. That's the specific answer to your question. But the related point is if your property is riparian and you do have riparian property rights, you can, without selling your upland, you can simply sell your riparian property rights to somebody else. And then that other person who has those riparian property rights gets to use them and you no longer own them. And I have seen in chains of title before where a piece of waterfront property, a beautiful piece of waterfront property, doesn't have riparian property rights, because a predecessor in the chain of title sold the riparian property rights to somebody else. And this is one of the reasons among many that I tell people, if you're going to buy waterfront property, you ought to have somebody like me take a look at the property before you close, because the riparian property rights account for anywhere from 30 to 40% of the value that you're paying for that waterfront property. And wouldn't you be disappointed to pay that premium to get waterfront property and then learn after you close, you can't build a pier?
Yeah. So one final question, and I'll let somebody else have a chance. So at what point, if in a situation where both property and riparian rights accrue to a particular owner, but an adjacent owner builds a dock across that perceived property line, at what point does that trespass become an easement?
The direct answer to your question is 15 years. So if somebody builds a pier that extends into your riparian area, you have the legal right to make them remove it. And we get these kind of cases more often than you would think. But if you sleep on your rights for 15 years, then you just lost the riparian property rights with respect to that pier being in your riparian area, and you lose the ability to have it removed. And of course, this brings up riparian, what is the footprint of your riparian area? And there is an article on my website that is specific to that point, how to calculate your riparian area. And I guess I'll just leave it at that unless did that answer your question, Peter?
I think it did. Yeah, thank you very much. Thank you.
We're preparing to file suit right now to deal with that exact situation. And in that case, we're getting ready to file for another client right now. We had to do bring in our consultant who's very good at figuring out when piers were built, because we knew that we had pulled the paperwork from the VMRC for the pier that is at issue. And we saw that the date on it put us at jeopardy of the 15-year mark we've been talking about. And it turns out that while we don't know the exact date the pier was built, we were able to get photos of that area that established that as of June 7, 2007, it had not yet been built. And within a year after that, it had been built. So we're using June 7 as our drop dead date. And we're going to get that suit filed probably next week, just so that we're not at risk of adverse possession dooming our client's case.
Does notification of the incursion interfere with the 15 years? In other words, at what point does the 15 years begin?
Well, adverse possession requires open, notorious, and hostile occupation of property as against the true owner. So from the moment that you meet those elements, that they invaded your area in a way that was open, notorious, and hostile, from that's what starts the clock running on the 15 years. And so if you're thinking,
even though we would notify VMRC or the city of the encroachment and object to it, the 15 years starts when the first pile goes in. Is that what you're saying?
I'm saying once they invade your riparian area, whatever that act is that invades your riparian area, that starts the 15-year clock, no matter that you objected to them building the pier, or you filed an objection with the city, or you filed an objection with the VMRC. That's not going to stop it. What will stop it is filing a lawsuit.
Okay, and then, well, then one other question. You're using riparian area, but I think in this case, the dock never gets to the riparian area, but it is down to where the mean low water mark is. So there's water under the dock sometime.
Um,
And I'm assuming that riparian, I mean, that mean low water line is the beginning of my riparian area. And it is part of my backyard, my land, because it extends out beyond. And in other words, his property is longer than mine. And the water comes up along his property where my property line goes all the way out to the end. Anyway, I'm sorry, that's too personal a question. I'll come back to you later with it.
Okay, I would encourage you to take a look at the article on my website on how to calculate your riparian area.
I'll do that.
That's where you want to go for that.
Thank you.
And then we
Okay,
had just one final question from Pam, and I think it's more of, her remark was that they get a lot of calls on large pilings and debris washing up on the shorelines. And so Pam, is the question then, whose responsibility is it?
Well, it's not a question, it's more a comment of, the abandoned vessel is a huge issue. But I think even more frequently it wasn't a question. It's just, as far as I know, it's the property owners. I don't know of any help except for, try to solicit help for Clean the Bay Day or something. But we get a lot of calls about big debris that's too big to just run out and pick up out of their wetlands and their mud flats and things like that. And I think it's up to them to get it out. I don't know of any help, just like there's not a lot of help for abandoned vessels either, but it happens really more frequently.
Yeah. Pam, what you've just described, just debris depositing on somebody's shoreline, whoever was responsible for that debris getting loose is, they were prohibited by law from doing that. But this is, again, just like the person who leaves the abandoned boat on your shoreline is prohibited by law from doing that. Figuring out who the accountable party is oftentimes very, very difficult. And so,
exactly. Especially with pilings. Pilings never had an identification marker.
Yeah. Yep, I agree. I think Vince has his hand up. Vince, did I get that right?
Yes, you do. The two quick questions. One is, as you know, we do a lot of cleanups on the water. And we always tell people, hey, if you can reach it from your canoe, it's okay to pick up trash along someone's private property line. But we tell them, don't get out of the boat. Does that seem to follow the guidelines? And it's almost always tidal.
Yes. So it sounds like you're coming at this from the direction of, we'd like to pick up as much trash as we can, but we don't want to trespass. Is that what's behind your question?
Yes.
Okay. I think the practical answer here, there's an academic answer and a practical answer. The practical answer, I think, would be, I would approach this the same way I would as if I was on the sidewalk out in my neighborhood and I saw as I walked on the sidewalk, I saw some trash on my neighbor's property that I wanted to pick up. I would probably feel comfortable picking it up from the sidewalk, if I could reach it from the sidewalk, even though technically speaking, me extending my hand onto their property without their permission could be trespassing. And to sort of take that analogy and apply it to the situation you described, yeah, while you're in the boat, you're not on any private property. And if you reach from your boat and technically cross the property line to pick up that, styrofoam food container that's sitting in the marsh, you might technically be trespassing, but I can't imagine anything bad ever coming from it. And I can see a lot of good from you picking up that styrofoam container. So I would say do it.
That would be because we've done many a clean the bay day from boats and are often reaching into wetlands and doing it. You haven't had complaints, have you, Vincent?
No complaints, but just want to make sure we're giving our volunteers a good idea of what they should and shouldn't do. And, we're using grabbers and nets, so they're not really reaching. They're using a tool to reach and get the trash. We haven't had complaint. We actually, there is one guy on Lake Holly that he wanted to see what we picked up to make sure we didn't take anything that was his. That is the only time we've had a complaint. Second question is, in Virginia Beach and probably other areas, there a lot of property lines on the map are shown going out into the water. And a lot of people believe that that means they own that bottom because that's where the property line is. My understanding is that's not the case, though, that's still state-owned bottom in tidal waters, and that the property line just extends out that far because for tax collection purposes.
I have run into this also many times, and Vince, you're correct. There are people who have deeds that show a property line going out into the water in a situation where they don't own that bottom. And I don't know why that deed was drawn that way. And and I often, as I think about this, I think about the old saying of somebody selling you the Brooklyn Bridge. And if somebody sells you the Brooklyn Bridge and you give them money, they'll give you a deed. And the fact that you have a deed, and even the fact that the deed was recorded, doesn't mean that you own it. And that's why we have title searches, for example. But title searchers don't really work very hard to figure out that property line that's shown out into the water. And the reason they don't is because if you live on the water and you go pull your file from your closing on that real estate transaction and you get your title insurance policy, you will see there's a carve out for the riparian property rights. They do not insure the integrity of your deed as respects riparian property rights. And so the title searchers, they don't really worry about it. And as a result, there's a lot of deeds that show exactly what you just described, Vince. Now there is some privately owned bottom in waters that you wouldn't expect, and it comes about through you've probably heard the phrase a king's grant. In the years prior to the American Revolution, I mean, this is your history lesson now, but prior to the American Revolution, when Spain and England and France were exploring North America, they under the international law of discovery claimed title to the lands they discovered, and those lands were all owned by the kings and queens of those nations until they conveyed it out. And then you may have heard about things like the different companies that got established to try and get colonies going. And there were some like Jamestown and other places. And so what the kings and queens would do is to induce people to settle, they would convey land out of this vast holding that they had discovered. I mean, the holding, I mean, think about like the Louisiana Purchase. France, Napoleon, the king, owned all of that property that is part of the Louisiana Purchase. And similarly, the King and Queen of England owned similarly large, vast tracts. And so to encourage settlement, they would issue a deed for a chunk of that land. Now, sometimes it'd be a really big chunk. You know, it could be the size of a county or half of a state, or it could be smaller than that. But a king's grant was no different than a deed that you and I get when we buy property today, other than it's usually much larger parcel because the purpose behind it was a much bigger enterprise. And the deed is signed by a king or a queen instead of by Mr. Smith, who sold his house to me. And when they made that conveyance, you didn't have the Commonwealth of Virginia saying they owned the bottom here and there. I mean, that king or queen owned the entirety of the landmass we're talking about. And so when they made their conveyance out, they could convey the bottom land if they wanted to. I've read a whole bunch of these king's grants, and some convey the bottom land and some don't. But once that bottom land was conveyed into private ownership, then it never got back into governmental ownership, because when we had the revolution, the American Revolution, if you win a war, then the international law of conquest says that you succeed to the title of the person of the country you vanquished. So whatever land that the King of England got through the law of discovery and didn't convey out to some enterprise to try and get them to establish a settlement like Jamestown or Plymouth Colony or some other colony, whatever land was still in the ownership of the king. When we won the Revolutionary War, the United States of America succeeded to that title. And so then how did it get to the state of Virginia? How did the bottom land get out of the United States and into Virginia? That's through the Submerged Lands Act that's in US Code. That is the United States conveying bottom land into the states. So then Virginia then got all the title to the bottom land that was still held by the King of England when King George lost the war. And so that's, and there are some areas around Hampton Roads that were granted by the king before the Revolution and are now privately owned. There's also some up around Irvington, Carter's Creek up in that area. And there's even some in one of the rivers in the middle, I think the Jackson River. I've seen cases where there's some king's grants and some privately owned bottom, and thinking the Jackson River. Long-winded answer, but you raised a really interesting point, Vince.
I won't even bring up oyster uses of the bottom, because Abigail's getting itchy on the time.
Get hungry.
Yeah. Well, look, great. Oh, Pete, go ahead.
Could I just in a quick one more time, I'm going to hold this up. I don't know if you can read it or not. But if you look at the lines that I have drawn and the little dots, those are markers that are in the ground that separate my property. You're using, I'm sorry, let me hold it up there again. But you're using riparian rights, and you're describing access to riparian rights. Where do they begin? I mean, the mean low water mark, if my land goes to the mean low water mark from the markers, right? That'd be my backyard, and you could not build a dock in my yard.
Right.
So, and riparian rights don't start beyond, they start at mean low water mark and beyond.
Yes.
Do they not?
Your riparian rights apply only in your riparian area. And your riparian area is going to have 4 sides to it. one side will be the line of mean low water. And then the opposite side to that will be the line of navigation. And then you're going to have side legs. And the two legs on the side of your riparian area are not going to be the extension of your property line from the upland. Just
No,
know
they
that going in.
They go from the marker straight out to the, I mean, out to where the navigable water is, correct?
They are straight, but they're not an extension of your property lines. from
Correct, I got it.
upland.
Yeah, got it.
And in my article on my website, I talk about the math of how that gets calculated.
Okay, thank you. I'm going to get that article down and I appreciate, thanks y'all for patience. I appreciate it. Thanks.
All right, anything else?
Okay. Well, thank you everybody for your participation, for hanging on, and for your good questions. I think we've run out of time though, but if anything comes up, I think you all know how to reach Jim. If not, you can give him a call at 757-502-7326, or you can shoot him an email at jlang@pendercoward.com. And we hope to see you on the next webinar. Thank
Are
you.
you gonna send the are the slides going to come out by any chance?
Yes, they will come out. We'll do a recap article and it'll go on our website,
Thanks.
and you'll get an email from us when that is available. And within that article, the slides will be present as well.
Thank you very much. Thanks a
You
lot.
bet.
And our next webinar, by the way, is Friday, June 10th at 12 noon. Subject will be living shorelines, and I have an extremely knowledgeable co-presenter who's going to help me make it very interesting and lively, and that's Vince Bowers, who's on the meeting today. So looking forward to working with you on that one, Vince. All right, thanks everybody. Have a good rest of your week.
Thank you.
Uh-huh.